Welcome to EPG Pathshala. This paper is the philosophy of law. The current module is equality. The objectives of this module are to understand the concept of equality and its significance to the philosophy of law, especially in relation to the Indian Constitution. This module was written by Garima Goswami, an independent research scholar in New Delhi. I am Akash Singh Rathore from the Lewis University of Rome. The preamble to the Indian Constitution speaks not just about equality. It talks about all of the spheres, economic, social, political. It talks about liberty. It talks about the rather grand claims that we all have in mind when we come together to form a political society, a political community. Now, this is not merely an arbitrary or rhetorical gesture. When you really think about it, the very concept of equality itself also requires a certain amount of interrelation with liberty and justice. Let's think about it like this. Let's assume that you want to assert your right to equality, which, as we all know, is guaranteed by the Indian Constitution in a series of articles, starting with Article 14, 15, 16, and various other manifestations like prohibition of discrimination or other forms of the right to equality. If you want to exercise your Indian constitutional right to equality, what is actually happening in that moment? In that moment, you have the liberty of conscience that allows you to assert your right to equality. And you also have a claim for justice. In other words, you have a situation which you regard as unjust, that your right to equality is not being enjoyed or recognized, and that you want to turn it into a just situation. In this respect, what the preamble to the Indian Constitution does by bringing together various concepts like equality of opportunity and political, economic, and other various manifestations of our general ideology about the nature of the Constitution and our goals, what it does is actually recognize something quite crucial about equality in terms of jurisprudence. That is, that you cannot have equality without liberty and justice. Now, what this module is going to do is going to discuss what do we mean by equality? Equality of what? Equality for whom? And it's going to do so in terms of both constitutional articles, 14, 15, 16, 17, and Supreme Court cases on equality and the nature of equality. In doing so, we're going to attempt to understand what equality is within the Indian context. Seeing it as a philosophical concept is something that is largely visited in various other modules throughout this paper. But in this module, we're going to try to concentrate on its legal traction. Now, I've mentioned the constitutional articles which convey these rights to equality. In Article 14, you find, "The state shall not deny to any person equality before the law or the equal protection of the law within the territory of India." Article 16 reads, "There shall be equality of opportunity for all citizens in matters relating to employment to any office under the state." Article 15 mentions how the state is against discrimination. For example, 15.2 states, "No citizen shall, on the grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability, liability, restriction, or conditions with regards to access to shops, public restaurants, hotels, and places of public entertainment, or the use of wells, tanks, bathing huts, roads, and places of public resort, maintained wholly or partly out of state funds or dedicated to the use of the general public." So this is some indication of the constitutional provisions guaranteeing equality in various forms. Let's look at it a little bit more philosophically. In his book, Inequality Re-Examined, Amartya Sen presents the reader with two essential and interlinked questions. Why equality, and equality of what? His argument is that both these questions are interdependent, and the more significant question is equality of what? In Inequality Re-examined, as well as his later book, The Idea of Justice, Sen presents the capability theory, which talks about ideas like equality and justice in terms of freedom to achieve instead of actual achievements. In Inequality Re-examined, there's a section on gender inequality where he quotes statistics of how the state of Kerala, for example, has very good quality of life for women despite being one of the poorest states in India in terms of the distribution of income. So Sen gives an elaborate reason in support of the capability theory using Kerala as his example. And let me read from what Sen says. The explanation of Kerala's success is the important space of basic capabilities has to be sought in the history of public policy involving education, including female literacy, and health services, including communal medical care, and to some extent food distribution, including the use of public support of food consumption of the rural as well as the urban population, in contrast with the rest of India. There are also other factors involved, including a more favorable position of women in property rights and inheritance among a substantive and influential section of Kerala's population, and the greater public activism connected with educational campaigns as well as politics in general. The history of public action in Kerala goes back a long time, with remarkable literacy campaigns in the native states of Travancore and Cochin in the 19th century. Now, let's not move away from Sen's approach, but what we have to consider is why equality? Equality of what? The answer that Sen is suggesting is why equality is because of clear, rampant inequalities. This is the premise, in some respects, of his idea of justice. What do we need to focus on? An ideal theory of justice or the fact of manifest injustice? So in Inequality Re-examined, Sen has something of a similar approach. He favors the question equality of what, however, because it allows him to further articulate his capability theory. Among the other questions that Sen asks, in addition to why equality and equality of what, are the answers that are given by a number of legal philosophers like Dworkin and Rawls to some extent. For example, what about equality of welfare, equality of resources, equality of opportunities for welfare, equality of opportunity as equal access to advantage? In other words, there are a number of rival theories about what sort of equality we are talking about and equality of what when we discuss that each person enjoys the right to equality. Thus far in the module, what we're trying to understand is that the preamble of the Constitution gives us a sense of equality in a context. The articles for equality, which are laid out in the Constitution, give us very clear prohibitions against inequality. In the philosophy of equality, such as presented by Amartya Sen, he asks the question, equality of what, or why equality? He gives his own answers in terms of the capability approach. There are rival answers to the question, equality of what, in, for example, the philosophy of Dworkin or Rawls, which can give you different answers such as equality of resources, equality of welfare, and so on. Now, that much being covered, let's move on to special privileges necessary to ensure equality of all. So we're going to discuss caste, gender, and disability. There has been and continues to be rampant discrimination against socially and educationally backward classes, castes, and as well as what may be regarded as the weaker sex, be it women, gays, lesbians, bisexuals, or transgender. B.R. Ambedkar, who drafted the Constitution of India, was aware of and rather sensitive to caste and sexual discrimination within the country. Special privileges or provisions such as reservations and the abolition of untouchability were included in the Constitution. In India, lower castes and some minority groups were considered untouchables. They were shunned from various social practices and had no access to economic benefits. It was therefore a requirement in the Constitution of India to abolish such a practice that reeked of discrimination and inequality. So you can have no robust right to equality if you have real everyday practices of inequality. The metaphysical need for actualization of concepts like equality arises from the fact that due to sheer chance, or what may be regarded as a morally arbitrary brute luck, some people are born rich, some people are born poor, some are associated with high class, some with low class, some are born female, some are born male, and so on. This is, from the point of view of luck, law, sheer luck. It's purely arbitrary. So the harm or the benefit that results to a person as a result of this brute luck is hardly considered to be deserved. The positive outcome of unequal treatment is referred to as a positive discrimination. Different countries have policies favoring positive discrimination, such as affirmative action in the United States, positive action in the UK, employment equity in Canada, reservation in India. Special provisions are made to compensate for the unequal treatment or inequality accorded to some sections of the community in order to balance the scales of justice. Opportunities for education and employment are given to certain socially and economically deprived groups, castes, and classes to bring them into a parity with the general category of citizens who don't face such discrimination. However, it may be argued by a libertarian that reservation quotas are an unjust way to pursue justice. In fact, in India, reservation was a temporary solution to kickstart the process of equality for a generation of economically and socially backward classes. However, the system of reserved quotas in education and employment still continues. In time, reverse discrimination was also seen as members of the general category who have no reservation quotas for them. It was also felt that they were disadvantaged for having ancestors who had had the good fortune of not being discriminated against. So, in other words, the ancestors were not discriminated against but practiced discrimination, and the contemporary people in the general category are discriminated against because of their ancestors' practice of discrimination. So these are all arguments that appear depending on the political theory that you have to back up your conception of equality and how to resolve rampant problems of inequality. Now, it's interesting to note that under the Right to Equality section of the Indian Constitution, the term equality is used only twice at the following places: in Article 14, which I had read, and in Article 16, which I had also read. Now, to an average contemporary urban Indian citizen residing in any metropolitan city, Article 15, which I had read out to you, might appear somewhat futile. But it's important then to inform such a citizen that prior to independence, and perhaps even till date, a number of people of the lower castes and classes are subjected to discrimination and are not allowed to use basic public facilities like footpaths, wells, or waters. Despite many positive laws being made in the colonial times, due to the Shastric nature of Hindu law, gross discrimination was observed even within the courts when injunctions were issued to disallow a person of a lower caste from visiting public facilities and some religious temples. The incorporation of these articles also reflects the specific context in which the Constitution of India was framed. However, today there's a need to observe equality in many other spheres formally. It is ambiguous, and the inclusive nature of the wording of Article 14 that gives us so much space within the legal system to grant the kinds of equality that weren't even conceived of in the time of the drafting of the Constitution. You can think, for example, of the equality for the third gender. In addition to discrimination against the third gender, we can also think of the Article 14 of the Constitution as having the scope to allow for overcoming the inequalities or disadvantages faced by the disabled citizens. So let's discuss these two groups of people: the disabled, or who are now referred to as differently abled citizens on the one hand, and the third gender, who have throughout history been discriminated against. But due to the implementation of the Constitution's Article 14 and its wide scope, we find that in very recent history, in fact the last decade, members of these different communities, the differently abled and third gender, have agitated, just as we had spoken about in the beginning, for a certain kind of justice. That is, they've advocated for their right to equality to be as substantive as those of other communities. Let's begin with the discrimination of disabled or differently abled citizens. There is no mention at all of special privileges for the physically handicapped or differently abled individuals within the Constitution of India. However, in some court cases, mention of Article 14 has been made to grant justice to the differently abled or disabled members of society. What is available for this section of Indian citizens is the Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Act, 1995. Despite the presence of this act, there was a need for a court-ordered mandate to the Union of India to make sure that there is no discrimination of individuals with hearing impairment and speech challenges in comparison to blind and orthopedically handicapped individuals in terms of transport allowance to be granted to those who were employed with the government. The particular case was called Deaf Employment Welfare Associate and Others versus Union of India. As per an official memorandum, the argument put forward by the Ministry of Finance was that it was, and I quote, not fair and just to equate the disability of deaf and dumb persons with those of blind persons, insofar as transport allowance was concerned. Now, the Disability Act did not discriminate between persons with different kinds of disabilities. Despite recommendations from the Ministry of Road Transport and Highways as well as the Ministry of Health and Family Welfare, the allowance was not granted. In 2006, when the Ministry of Finance advised the Ministry of Health and Welfare to refer the issue to the 6th Central Pay Commission, double the normal rate of transport allowance was granted to blind or orthopedically handicapped government employees. However, the same was not done for those with impaired hearing. In February of 2013, the Ministry of Finance was approached again by the Ministry of Social Justice and Empowerment. The Ministry of Health and Family Welfare argues in favor of similar travel allowance for individuals with hearing impairments, mentioning that according to the Disability Act 1995, hearing impairment is classified as a disability and traveling is a risk for hearing impaired employees that can be equated to that of any other disability. Moreover, they cannot communicate and more time and effort is required for them to reach any destination. So these were the two sides of the argument as to whether people who are deaf should be able to enjoy the same level of extra compensation that the disabled are granted through the Disability Act 1995. Well, what did the court decide? According to the judgment of Justice K.S. Radhakrishnan, and I quote, there cannot be further discrimination between a person with disability of blindness and a person with disability of hearing impairment. Such discrimination has not been envisaged under the Disabilities Act. In other words, what we find is that the Supreme Court held that the practice of the ministry and advised by the Ministry of Finance and implemented in the 6th Pay Commission violated Article 14 of the Constitution of India. Now, this is very interesting because, as I had mentioned, Article 14 makes no mention of disabled or differently abled citizens in the people who cannot be discriminated against or the grounds of discriminating between people. It was also mentioned that comparing the suffering of an individual with a hearing impaired person to that of a visually impaired person violated Article 21 of the Indian Constitution, which assures protection of life and personal liberty. So what we find in this case, what Justice Radhakrishnan is pointing out quite clearly, is that the interrelation of various principles, for example, equality in 14 and liberty in Article 21, which we had seen in the preamble to the Constitution, is always played out when we discuss the way that equality or the struggle for equality is seen historically through various cases and in civil society. We can see this again quite clearly in the discrimination against third gender. The American philosopher of law, Martha Nussbaum, has written a paper entitled India Implementing Sex Equality Through Law. In this, she makes the critical observation that the framers of the Indian Constitution understood the goal of equality in terms of an end to systematic hierarchy and discrimination based on both caste and sex. However, when Nussbaum wrote this article, she thought particularly about gender equality for women and not the third gender. It's only in 2014 that a decision was taken by the Supreme Court of India regarding legal gender recognition of transgender people in the case that was called National Legal Services Authority versus Union of India. The case was that a positive development for pre-existing Indian laws had only recognized the genders male and female, and there was no provision for a third gender. And this prohibited third gender individuals from claiming legal rights in relation to marriage, inheritance, taxation, adoption, and general welfare. The absence of legislature in this case was what discriminated the third gender against recognized binary genders. In the judgment, again, of Justice Radhakrishnan, which was endorsed by Judge Sikri and others, it was finally acknowledged that the transgender community, which comprised of hijras, eunuchs, khotis, and the like, had been subjected to both prejudices and disadvantages, not in recent past, but at least since the 18th century. Discrimination faced by this community in different sectors, be it healthcare, employment, education, has led to social exclusion. Now this, according to the court, violated Article 14. Article 14 is gender neutral, and it grants the right to equality to any person, and any person is in quotation marks. That means you don't have to be a male or a female. It should be and is applicable to men, women, and the third gender alike. So a transgender group is also entitled to equal protection under the law. As per this very important judgment, the right to choose gender identity also falls within the scope of Article 21, that grants all citizens the right to life, and Articles 15 and 16 of the Constitution of India, which prohibit various types of discrimination, including discrimination on the basis of gender. So, the judgment equated sex with gender and declared that any gender bias or gender-based discrimination is also prohibited. It was declared that it was a fundamental right to not be treated differently just because one does not conform to stereotypical binary genders. It was also recognized that the transgender community qualifies as socially and educationally backward. Hence, affirmative action should be taken by the state to rectify the injustice done to this group for centuries. Finally, it was recognized that gender expression and presentation was protected by another fundamental right, the right to freedom of expression, mentioned in Article 19 of the Constitution. So despite any absence of statutory guidelines, the central and state governments have to grant legal recognition of any gender identity as male, female, and third gender. The Indian government was also directed to address issues pertaining to education, society, and health with respect to third gender. So let's begin to wrap up and bring this discussion of equality under the Indian Constitution and in the Indian context to some summary and close. We had begun with the preamble of the Constitution. The preamble of the Constitution doesn't separate and individualize all of the sorts of rights and ideals that we all know as citizens of India should be in some way together implemented in order for us to say that we have created a just society worth living in. That means that we don't conceive of equality merely as social equality, we don't conceive of it merely as political, we don't conceive of it merely as economic. We speak of social, political, and economic equality. Just the same, when the preamble discusses these conditions, it also discusses liberty of thought, liberty of conscience, religious faith, and it blends and mixes together all of these crucial jurisprudential and philosophical rights notions in a pattern that has to be collectively met in order for any particular one of those to be robustly or authentically felt. In other words, having equality can hardly be enjoyed unless I have liberty as well. In this discussion of the preamble, it foreshadows the way that any demand for equality is actually reliant upon two other crucial notions. One is liberty, the liberty of conscience to know that I deserve it, and justice, the demand for that equality through civil actors or through courts of law. We moved on then to discuss equality in a philosophical aspect, that is, through the works of Amartya Sen in his Inequality Re-examined, which we showed was in some way parallel to his recent great book on the idea of justice. Just as equality turns out to be crucially important, not because of any ideal theory, but rather because of rampant inequalities, just so justice is not to be first perfectly carved out like a Platonic form, but rather we should begin with the rampant injustice we see all around us. Now, the clearest injustice that we see is, of course, the rampant inequality that each of us sees on a daily basis. After moving on from Sen's presentation of equality in a philosophical perspective, we decided that that question, equality of what, can be answered in a number of different ways, and it has been answered by different legal theorists in different ways. Equality of resources, equality of opportunity, equality of welfare, and so on. We decided to look at equality in particular concrete cases not just of inequality, but in the movement of the judicial system in an attempt to rescue the justice of equality. So in other words, seeking justice to remedy inequality. We pointed out two particular cases where this is salient. One is in the case of disabled people, and the other was in the case of the third gender. Now, in both of these cases, what is crucial to note is that the framers of the Constitution in no way envisioned this sort of equality. So in some respects, the scope of equality built into Article 14 is so wide that we can continue, as society evolves, to see that more and more communities who have been excluded should actually be included into the significance of equality that is put forward through Article 14 of the Constitution. In the case of the disabled people, there had already been an act of Parliament which demanded their equality, but the government had not implemented that act adequately, and consequently, a motion was put forward that a certain group of disabled people are being treated unequally, and they deserve the kind of positive discrimination of other disabled people. By doing so, the court, in its decision, said, yes, Article 14 does cover all disabled people, and we cannot distinguish between certain kinds of disabled people because all of them face disadvantages. It also recognized that it wasn't just Article 14, but also Article 21 that could be read in relation to these, this case. So what the court had served to do is emphasize what we have been discussing in this module, which is the relationship of each of the key legal philosophical concepts like equality, liberty, and justice, recognizing them in relation to one another as the means through which any one of them is realized. We saw this also in the case of the third gender, which the Supreme Court has recently declared is subject to all of the rights that anyone from the binary genders, male or female, are able to enjoy. In this respect, we have discussed the concept of equality not only from the point of view of philosophy, but also from the vantage point of Indian constitutionalism and certain crucial cases that have to deal with the way that equality is ultimately achieved in the political framework. Thank you.